And so some number of years later, he asks Myman for a loan to pay off two properties, not more than the amount of the properties, but the amount of the mortgages outstanding on the properties.
Well, but his mother-in-law ends up with a lot of this money, at least in her name. You can dispute whether she has control, but it got pretty close to him.
So the mother-in-law was the mother-in-law did not have actual control over it, let alone Toledo having actual control over it, and it wasn't her money in any real aspect. She was used as a name for tax purposes for Myman, and as is indicated in Myman's testimony, he had a direct contact with her, and so getting close to something when all of the indicators otherwise point the other direction is certainly not enough to establish a crime. It's not enough to establish probable cause that a crime occurred. But I'd like to sort of complete the analysis since we're looking at the government's allegations. You have this $500,000, and this is somebody that is Myman has ingratiated himself with Toledo. He has held himself out to be this sort of illustrious billionaire with projects all over the world. As is very clear in the record, he had prior dealings. His testimony is that he had prior dealings with Peru, that he'd been involved in these hundreds of millions of dollars of currency transactions, disguising the location or the source of money to pay down debt, and being this intermediary for countries and moving millions of dollars around the world. That's his public persona. That's what he holds himself out to be, and that's how he ingratiates himself to leaders like Dr. Toledo. But in doing so, the idea that he could loan Dr. Toledo $500,000 out of his supposed hundreds of millions or billions of dollars of personal net wealth, when Dr. Toledo is suffering with a modest income in the United States and these extortionate interest rates from mortgages in Peru, the idea that would show that Dr. Toledo was aware of this massive agreement, $35 million, why he would be asking for basically just some relief from predatory mortgages doesn't line up with the knowledge of someone who understands that they have $30 million coming to them. So I understand that there's concern about it. Obviously, in retrospect, if he'd had any idea that Myman had secretly collected tens of millions of dollars, he wouldn't have associated with him. But it's evidence that, while at first blush could be considered suspicious, but when taken in context of the total amounts of money involved here, and if you look at face value, the allegations against Dr. Toledo for collusion and then money laundering, the idea that the money laundering allegations are that Dr. Toledo directed the flow of funds, which would necessarily require that he knew where the money came from. He knew and directed the flow of it through Myman's shell companies. But then at the end of directing all of that money and supposedly committing the act of money laundering, he stops short and doesn't ask for it to go the step further to actually transfer him the money. That doesn't make any sense at all, and that's what obliterates probable cause. Just as much as the contradictory testimony, internally contradictory testimony, absolutely incredible testimony of Myman and Barata are not available or not sufficient to establish probable cause, it's common sense that buttons this up and absolutely obliterates probable cause in the end. Why would someone risk their life to solicit $35 million in bribes and then not deliver on the supposed promise and then not ask for the money once it's been paid? None of that makes sense.
Let me ask you this, and I apologize if this is an unfair question, and you don't have to know the answer. What does a trial in Peru look like? For example, would Barata and Myman have to testify?
My understanding is that they would have to testify. I think that my understanding, and I cannot profess to be an expert on this, is that their deposition testimony under oath so far is what would be presented to the judge to eventually issue a formal charging document. And again, I think it may not be relevant to the probable cause determination, but I think it's important for the court to know that shortly after the court denied our motion to dismiss for lack of a formal charging document, the Peruvian authorities moved the case back in the investigatory stage, and that's where it is today. So again, as we indicated in our briefing, there is still not a formal charge. It has not been presented to the court for formal charge. The intermediary stage.
But it's your understanding that Barata and Maiman would have to testify in a trial. They couldn't just show the transcript of their prior testimony?
I believe so, but I'm not an authority on that. So.
Oh, okay. I mean, it'd be a long cross-examination. There's no doubt that there would be a lot that the defense lawyers could explore with them.
But Your Honor, if I could draw the court to something that the court deals with, possibly even on a daily basis, and that's the decision about whether to issue a warrant based on probable cause. As the court is familiar, every time informant testimony is presented in either a complaint or a warrant affidavit asking for either the issuance of an arrest warrant or a search warrant, there's a determination of probable cause. And there's always that footnote that is dropped, which says, this information is provided by an informant. I have a basis to believe, because of their prior good information, that they, in spite of the fact that they are either being paid to provide this information or working off another case, that they're indicia of reliability based on that. If the court were presented with the testimony of people that were constantly contradicting each other and had already been determined to be not credible as to material aspects of an agreement. And again, I disagree with the court's sort of characterization of Barata and Maiman's contradictory statements as to the agreement. This agreement, the aspects of the agreement, Dr. Toledo's knowledge and input in the agreement is the only thing that would make it a crime on Dr. Toledo's behalf. But again, the government is correct that we are not arguing that no crime occurred here. Absolutely, the evidence establishes probable cause that a crime occurred on behalf of Maiman and Barata and Odebrecht generally, as well as a number of Maiman's associates. But the contradictions are relevant to Toledo's knowledge of the existence of that agreement, let alone his input into that agreement to direct the agreement. So if the court were considering this in a warrant application, I would certainly hope that the court would have extraordinary pause in issuing a warrant where the only evidence is contradictory evidence presented by people who have been found to have lied under oath, contradicting their own statements under oath over and over again. And so in that sort of, in that day-to-day consideration of a warrant, this would be, especially with what the government is objecting to the court's consideration of, which is, I can't imagine a situation with the government's Brady obligations in the United States where they would present an affidavit to the court, including informant testimony, but then either learn about later or know at the time that there was contradictory evidence, that there was much more testimony, and then not present that. It would be savaged in a Frank's challenge to a warrant. And so I think in that kind of analysis, this presentation to the court, it's not just some allegation that a crime occurred, but there has to be probable cause to believe that the crime occurred. And when you have witnesses that are just so fundamentally unreliable, and not on minor details, not on discrepancies or minor inconsistencies as the cases that are cited by the government describe, but absolutely fundamental underpinnings of this agreement. And then you look at what actually occurred, the practical sort of extrinsic evidence of what occurred, when the money was transferred, who it went to, and the relative tiny amount that went to Dr. Toledo, as well as the absolute lack of demand by Dr. Toledo of any of these finances. The only conclusion that can be drawn is that Dr. Toledo was unaware of this agreement, had no benefit, and took no action on behalf of Odebrecht outside of what he was doing otherwise as a president. And so it seems that it's well short of probable cause. It's bare allegations unsupported by the evidence submitted by the government, and certainly unsupported by the complete record which has been submitted by the defense.
Alrighty, thank you, counsel. Let me hear from the government. And one question I would like the government to address is that in Exhibit G, Maimon seems to flat out admit that he skimmed off about a third of the bribe money for his own benefit. And I see that Peru certainly did not include that testimony in the evidence it submitted to the United States. Does the omission of that evidence and the content of that evidence show that Maimon is just completely untrustworthy?
Thank you, Your Honor. I'll start with that question. No, it doesn't. I mean, certainly the story of where all the money has gone has evolved over time, and that is due in part to the fact that initially the documents showing the money trail hadn't been reviewed or presented. And so once those documents were produced, the allegations were crystallized more clearly. But regarding whether the money went to Maimon or how much money went to him, it doesn't change the allegations that some of the money was used to purchase properties that have been tied to Toledo. The allegations regarding Maimon's money don't change those allegations about the properties. And they don't undermine Maimon's credibility as a witness either. I mean, I think it's not unrealistic to think that a witness might change his story about how much the bribe money he was receiving. And indeed, Maimon explains that there are some inconsistencies about his connection to the money. You know, Your Honor was asking about Ekateva earlier, and Maimon says in his 2013 testimony that it was his company and that he bought the properties that are at issue in this case. But then in his later testimony, he explains that, well, actually, as soon as the Ekateva scandal broke, Toledo came to him asking for help. And that was why he claimed the company and the properties for himself. But in fact, that he didn't actually know about the property of the company until he read about it in the news. So there has been an evolving story in terms of exactly what Maimon has been doing to help cover up this bribe. But certainly, there's no evidence that even if Maimon received a third of the money, that money also wasn't going to Toledo. An example of this would also just be the loan, as Your Honor has pointed out, which even if it was a loan, although I don't know that we have evidence in the record to show directly that it was ever repaid, it still shows that Toledo was benefiting, at least in some way, from the Odebrecht money. If I can just address everything that was just said, I think you can pretty much only accept what was just said if you find Barada and Maimon's statements not to be credible, and that's something the case law prohibits. So the court in Colmar, which is a case from this district, expressly says that extradition fugitives have no right to attack credibility. Similarly, the court in Santos explained that fugitives can't offer evidence that would contest the credibility of original statements, and it cited two cases from the Seventh Circuit and Second Circuit that say that extradition courts should not be making credibility determinations. You know, there's been a reference to a comparison with obtaining a U.S. warrant, but that's not the case what we have here. I mean, there is still a sort of preliminary examination of the evidence, but in an extradition case, the criminal case is in a foreign country. That's where all the evidence is. That's where the trial is going to go forward. And so credibility determinations should be reserved for that forum. But in any event, the statements that have been provided by Barada and Maimon are in fact credible. I mean, they're providing firsthand accounts of events that they themselves eyewitnessed and are admitting that they in fact participated in. They provide myriad details. Their accounts are also generally corroborated by other evidence in the package, at least to some extent. So the inconsistencies that defense counsel has complained about are minor. If you look at the big picture, both Barada and Maimon agree that there was a bribe agreement that was reached toward the end of 2004, that Odebrecht paid money pursuant to that agreement beginning in 2006, and they're both quite clear that it was their understanding that the money was intended for Toledo. Regarding the bribe meeting, what the evidence shows is that there wasn't just one meeting where the bribe was consummated. It was a gradual process that was the product of a number of meetings. So it's also not correct that, as defense counsel claims, Maimon says that there was no meeting to discuss the bribe. There's no such express statement that I'm aware of in the record. He discusses a few different meetings that are held in Rio, and he doesn't clarify that the bribe was discussed at them. And I think there's one meeting when he specifically says that the bribe wasn't discussed, but he's conflated a bunch of different meetings in his filing, and again, he did so today. And as the court noted, Maimon himself may have jumbled them a little bit as well in his own memory. Just to respond briefly to the point that Toledo's actions were not those consistent with a sitting president, well, there's evidence in the record indicating that witnesses say otherwise. There are witnesses who testified that Toledo's participation in the tender process by holding meetings in the government palace and asking only about the highway project and not the other public works projects being discussed at those meetings, seeking to shorten the time frame for the project. Witnesses say that that was not usual conduct. Meetings that were held at the government palace, both for the pro-inversion board meetings and also there's the log from the government palace that documents meetings between Toledo and Barada. I don't think it's necessarily clear that meetings between a sitting president and the head of a public works project were a common occurrence. I
have the same reaction when you talk about Toledo's conduct as when the defense talks about Toledo's conduct, you know, in terms of his participation in the project, which is kind of, so what? I mean, he can be an idiosyncratic president. He can, you know, have lots of meetings when other people wouldn't and push forward projects that other people might not have pushed forward. The issue is just, was there a bribe? And that, so I don't know, that doesn't strike me as very persuasive that the things that he did in office to push the project forward, there could be all kinds of reasons for that. The issue is just, was there a bribe? And even if he might have done the same things in the absence of a bribe, it just kind of doesn't really matter.
Agreed, and I think it's certainly consistent with the bribe agreement at the very least. And you know, regarding the claim that it's not possible that Toledo didn't know about the agreement, that's just not possible if you take into account Barada's testimony saying that he personally was delivering cash to Toledo and that Toledo was pressuring him to continue payments of the bribe money. And it's also not consistent with the trail of money that filters to properties that were unquestionably purchased by Mr. Toledo's mother-in-law and that were also linked more directly to Toledo given his involvement in those purchases. Regarding the laundering of the money, the fact that Maimon receives some of it. I mean, he forfeits only $5 million of it in his cooperation agreement. And, you know, as I said, I don't think this detracts from the fact that Peru claims that other money went elsewhere. And that's really the meat of their laundering claims in terms of linking it back to Toledo.
Let me ask you a question I posed to the defense. The judgment of effective collaboration makes clear that Maimon did personally get enriched from this money. And then the cross-examination by defense counsel leads to those admissions as well in his January 2020 deposition. I know you've objected to everything that's outside the extradition request on the ground that it's contradictory. Do you think that that evidence of Maimon's personal benefit is contradictory to the government's evidence?
I do, but I think the bigger problem with the cooperation agreement is that it's only going to Toledo's defense, which is that it was Maimon and not he who committed this conduct. And Santos clearly says that evidence going to that kind of defense, particularly one that's premised on an argument of credibility, is not admissible in an extradition proceeding. I also wanted to address the claim about all the money filtering to Ecoteva. I mean, I think a lot of defense counsel's argument is premised on the notion that Maimon was controlling Ecoteva through the nominee agreement, but that argument falls flat given Maimon's testimony that he actually didn't control the company. If in his explanation as to why there was the inconsistency in his statement in that regard. I think it also goes to the testimony about trying to cover up the Ecoteva connection, shows the lengths to which Toledo was willing to go to try to conceal the connection between the Odebrecht money and himself. So, I mean, I think given all this voluminous conduct or voluminous evidence connecting Toledo to the bribe agreement and to the money, there's only one answer, which is that there is more than ample probable cause that Toledo committed collusion and money laundering. And to find otherwise, this court would have to improperly engage in a credibility determination. It would have to find that Barada isn't credible. It would separately have to find that Maimon is not credible. And it would have to reject all of the other evidence that demonstrates Toledo's criminal conduct. So unless the court has further questions, I would just conclude by asking that the court should deny Toledo's motion to deny extradition based on probable cause. And I would also say, I would request noting that the court has rejected Toledo's other arguments in defense of extradition and that Toledo hasn't otherwise contested the requirements for certification. I would ask that the court also find that all 5 requirements for certification have been met and issue an order finding the same, certifying the request for Toledo's extradition for consideration by the Secretary of State.
Alrighty, thank you, counsel. I appreciate the argument from both sides. I will take the matter under submission, and I will hope to get a written decision out within a few days. The matter stands submitted.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, everyone. We're off the record. Court is in recess.
Recording stopped.
Mr. Toledo, you can hang up now, please. Thank you. Thank you, Emma.
Thanks, guys. Have a good weekend.
You too. Bye.